Hey, right, guys. Welcome everyone. Let's get to it. Basically, the usual stuff. Please don't put personal data into the chat or, in fact, any comment section in the YouTube channel. Just again, I say it all the time. If you want to ask a question, just ask it as or about just a hypothetical person. Um, Live chat tonight. I'll just ask you to rephrase it and start again. If you put it on the comments, I'll basically prioritize those people who have actually asked questions in the third person because it just helps me out as well for various reasons. So that's that bit. Also, it's not legal advice. We are just trying our best to be helpful. We try and share different resources as we go through tonight. But yeah, obviously you can't rely on this stuff. It's not that just isn't that sort of relationship between us and you. Nevertheless, it is aimed to be, as I say, helpful as possible as we can make it, basically. So um, right, there's a little bit of gossip from me this week, actually. Some really interesting LGO reports, some big payouts, basically, and it's kind of sort of normal stuff. So I'm actually going to share the screen just before we get into the questions, because I just think this is useful stuff, and I'll put the links to these in the comments as I go through. So let me get this right. So this one, yeah, so there's two of them. So here we go. No, where's it gone? Let's try again. No, Sharon, can you see that? Because at the moment it's saying I'm sharing it, but it's not.
See the 2301421 LGO, what happened,
Okay, cool. I can't see that, but well, I can
how
see
I
it, but not on the right
considered
screen.
this complaint. Yeah,
Yeah, Herefordshire, yeah. Yeah, yeah,
yeah,
yeah. Okay, right. Okay, so this is Herefordshire. If you want to just jump the gun and just Google it yourself, you can just Google this code here. But basically, what we have here is a family. I don't know how many children they got, but and this is just classic LGO decision. So you've got, what the LGO does. You've got the bits that fall outside the investigation. You've got other bits and pieces. You've got the law and guidance, which is a fantastic place to learn about the law. This is how I did it. You just read through these bits because it basically just sets out the key bits around the law that apply to this case. So stuff around temporary accommodation. It then gives a summary of what happened. And so this family were owed domain housing duty from summer 2020. They were then put into TA, which was, I think it was overcrowded and, yeah, severely overcrowded and had some disrepair issues. So they were then put into a hotel for 7 months, then went back to the property once the landlord had carried out the repairs. And effectively, so the first element of the complaint was not upheld. So that was, in one sense, a minor thing anyway. So there's two main elements there. So one is the fact that the council failed to deal with the disrepair issues in a timely manner and properly, and then also the fact that they didn't provide suitable temporary accommodation to this family. And basically, the LGO recommended that the Herefordshire Council pay the family 13.5K compensation for the stuff that's already happened. And if I'm reading this right, and I've only just scanned through it, but also pay £200 a month starting December 2023 for every month that they're not provided with suitable accommodation. So big, yeah, a lot of money. And this is not unusual. It's not unusual. I mean, we've seen cases. I'm involved in trying to help someone out in a case like this week where there's just really, yeah, shoddy temporary accommodation. So that's just an idea of kind of how this all works. So that's the first one, and then the second one. Uh, can you see that, Shannon? So it's should be Manchester,
yeah.
yeah, yeah, cool. So this one is right. Again, I've scanned through it. So I think it's a lady who's got autism, and she's her and her daughter were subjected to abuse from the partner, and this one's interesting because there's just so many recommendations. So again, you've got the really good bit around what the law actually says. You've got the thing, the bit the law says about council's duty to make reasonable adjustments. So in this case, the lady said she had autism, and that meant she struggled to take in information. And basically, the council was not able to give any evidence that they'd done anything differently. So whereas they should have kind of made sure that when they were talking with her, they explained things properly and all that kind of stuff, they didn't. Um, so there's a lot of stuff happened, as you can see. Yeah, so it's a long thing, but again, in the agreed action here, there's a lot of different points. I've never seen this many points made in a agreed action. So first of all, they've got to make an apology in line with their guidance on making an effective apology. Basically, making sure that they immediately have temporary accommodation suitable. Um, discuss with their reasonable adjustments, make sure that's sorted out. So £1,000 for avoidable distress. and then £300 a month for each month she remained in unsuitable accommodation since the council should have accepted the main duty, for the total of £4.5 grand. So again, I think that would mean that the total was £5.5 grand, but sometimes I lose track of the stuff. Um, and then the council should, and this is why it's so important to complain as well, not just for your own situation, but because you get system improvements. So the council should also take the following action. So provide training and or guidance to relevant staff about autism and reasonable adjustments. Remind relevant staff to record their consideration. So it's just basically a whole load of stuff about improving the way the staff deal with stuff. So down the bottom, they're using this case as an example. Discuss with relevant staff the challenges and barriers to victims of domestic abuse can face in leaving abusive situations, and identify the steps can take to support victims and create the best opportunity possible for them to leave. So just basically really good stuff that the council should have done. They didn't. But again, it's just that kind of that requirement for the council to just up their game. So there were probably more this week. There's quite a few that came in. I tend to ignore the London Council Ombudsman ones because they're basically always the same, just follow a pattern. But the ones outside of London tend to be the more interesting ones. So yeah, so that's yeah, check it out. Have a little, have a look through that stuff because you can learn a lot from those decisions. And it does seem that, I don't know if it's my imagination, it does seem like the council, the LGO is basically sort of zooming in a little bit on unsuitable TA and that sort of stuff, and kind of putting some pretty big payments through. So where you've got a council like Croydon who says, oh, we haven't got any money to basically provide suitable accommodation, if you use these kind of amounts, suddenly it does actually start to motivate councils to act lawfully, because for once, the penalty is actually more than it would be that they don't have to pay if they don't do the law properly in the first place. So let's get through the questions. So as always, we're going to start with the questions that have come in the comment section during the week, and then we're going to move across to the ones in the live stream, just so we don't lose track of everything. It stays fairly clear cut. So the first question is, if I can once again share the right screen. Here we go. So first question, I have a friend who was discharged from hospital into accommodation provided by the council. After the relief period, they led him to believe he would be put on the housing register. 2.5 years later, he's no longer priority need. It took them that long to make the main housing duty decision, and now he's been hounded to leave the temporary accommodation, given with nothing in place. To top it up, they've refused to put him on the housing register, and the almost 3 years seem to be in vain. What options can he be offered in a situation like this? He's appealed the decision and is waiting the review decision. So that means he's done the right thing in terms of challenging the kind of current situation, but it kind of raises this interesting idea that certain priority need, if it's arising from vulnerability, will. So if someone breaks their leg and comes out of hospital, then be priority need when they first come out, but 6 weeks later when the cast comes off, they wouldn't be, because their leg's better. And that sound, we don't know what the health issue is here, but it sounds as though they were vulnerable as they've recovered after the hospital stay. Effectively they've kind of recovered to a point where they're fit and healthy, and therefore they're no longer in priority need. Now the short answer to this for me is actually I don't 100% know, but I've got some thoughts about this. So my first thought is that councils are bound, once they've accepted the relief duty, which does appear to have happened here, they then have effectively 56 days before the relief duty ends, and they make a final Section 184 decision. And in some exceptional cases, there would be an additional 3-week extension available to the council. But we're looking at 11 weeks, not 2 years at 8 months. And the fact that the council, that council's failure to issue a decision when they should have, may well have actually resulted in them losing the assistance that they'd be owed in the main housing duty. I don't know this for sure, but I would potentially just be ringing up the local government ombudsman's helpline and just asking them, is this something the LGO could actually look into? Because certainly I know the LGO will recommend things like, if there's been a delay or there's been like a mistake a long time ago, that part of the remedy will be about putting it back to how it should have been. So, for example, if there was a delay in accepting someone onto the housing register, then the LGO would say, backdate that person's activation date, to the date it should have been. And so I don't know if I've never seen this before, but I don't know if potentially the LGO would be able to say to the council, you need to make the decision as if you were making a decision on the date that you should have made it. And if that person was in priority need at that point, then I don't know. I don't know this for sure, but that's what I'd be asking the question. the council is certainly not allowed to delay a decision so that that person's no longer in priority need. So the classic example is someone's 17 years old, which means they're automatically in priority need. Councils basically delay making the final decision until they're 18, and then that person's no longer in priority need. That's not legitimate if they've delayed it for no good reason. So again, there might be some stuff you could kind of pin the council on that in that way. But I don't know. Again, Shannon and Will, have you ever seen anything like this before, or kind of have any thoughts that I haven't had about this one?
Um, I haven't dealt with this for a long time, but a long time ago, I think I looked into this, as you say, in connection with the ages of children. And I think the question is answered by the fact that the council have to assess what your status was as at the date when you applied. So they can't, I mean, obviously there may be some things like if you had children living with you when you applied and they moved out, that would be something they could take into account. But what worries me in this case is that it seems he was maybe even accepted as being in priority need at the beginning, and then they take a year, 2 years and 8 months to process the application. So I think they should be saying that if they're when they've discharged, when they get to the end of the 8-week relief duty or the 2 years, 8 months working on the relief duty, they should consider whether he was in priority need at the date when he applied, which would make it a stronger appeal. But the other problem I had with this case was that, unfortunately, the fact they led him to believe he'd be put on the housing register. I mean, they're not under any obligation to put him on the housing register. I mean, you've got to make an application for that, as far as I can see, and he should have perhaps checked that.
Yeah, I mean, he would have, because he's under relief duty, he would have got reasonable preference on the. So I mean, I don't know what the way the admin would have been dealt with, but he would certainly been able to get onto the housing register if he filled in the right forms. I mean, again, my experience is mostly in Bedford Borough. They do this for people. So if you make a homeless application, part of the work they do is to get you up and running on the housing register, because it helps everyone. And that's why it's so important to be providing evidence. So that's not so. That's new to me. Well, I always thought that they had to make the decision on the date of the decision date or the review date. So, for example, if you asked for a review decision, then they would make the decision on the facts on the date that they made that decision, rather than the application was made. Because I've certainly worked in cases where you're applying. Let's say you're asking for a review of a non-priority decision, and so you get medical evidence and so on, in which time the council will offer suitable accommodation for that person, which they then accept. Their review decision would then come back to say the person's not homeless, rather than actually anything at all about whether they're in priority need or not. So that kind of almost gets lost, and councils will often do that because they can see that they were wrong, so they would rather house you so they don't have to actually kind of own up to it almost. But I'm not.
I agree that bit I'm with you on, but the other side is if they say we accept you're still homeless, but you're no longer in priority need. I think that's unlawful, because it's a question of whether you're in priority need at the date of your application.
Okay. Yeah. I mean, I'm interested to sort of see the small print of that. I mean, certainly.
Yeah, me too.
I remember one of the first cases I saw, and I didn't understand housing law at all at the time. Was a couple who was street homeless, and the lady was pregnant, and they basically, it was Bedford. They delayed making a decision until after the kids had been removed from their care. So they kind of knew that children's services were going to remove the children, and they just waited until it happened before they made the decision. Whether, as I say, this was before I knew anything about this stuff, so I don't know if it was right or wrong to do that. But my guess is sounds a bit shady. But I mean, I would potentially in this case be looking back to if the PHP, for example, said that they should be on the housing register and anything in writing, I'd be looking to kind of hold them to their word on that. But yeah, I don't know. It's an interesting question. I'm not sure how much use that answer was really, other than you're absolutely right to challenge the decision and see what happens with it. But I think if nothing else, the LGO would be able to make a finding on the delay, because 2 years, 8 months is whatever it is, 2.5 years longer than it should have been, and you get I don't know how the payment would be calculated, but you'd get a payment for like uncertainty and distress or something like that, in terms of just because you didn't know what the outcome was. let alone whether or not the actual decision should be that you're in priority needs. I mean, the fact is, when they're saying they're no longer in priority, I'd say that maybe they were first of all put in interim accommodation because there's reasons to believe they might be, and then a decision was never actually issued. That would be my guess, but I don't know. This might be one we return to if the person just kind of comes back to us and puts us right about a few things.
Would you be better off making a fresh application and sort of
I mean,
saying, look, there was reason to believe that I could have been in priority need last time, so on the basis of that, make a fresh application and complain about this? Like, it's a bit mad that 2 years, 8 months, like you say, like what was in the PHP for nothing to have been done, like no housing register application, no anything. Like there's a complaint in there, and potentially a subject access request to see what they have been doing in that 2 years and 8 months.
Yeah.
I
mean, I think that just making a subject access request, it just gives you that black and white evidence to the LGO through the complaints process. So just for those who haven't seen this before, you complain, you make a formal complaint, ideally to the chief exec. You just ignore the council's own complaints policy, to be honest. There'll be a 2 or 3 stage complaint process within the council. Once you've exhausted that, you can then go to the LGO. And the first stage complaint will almost never be upheld because the council just trying to see if you give up. But second, like the final stage complaint at the council is more likely to be reasonable. And I mean, I guess, it also depends, appealing the decision. I'm not quite sure if they're appealing the fact that they've now been found non-priority or something else. I don't know, or just the fact the decision to not allow him onto the housing register or something. So it's as I say, that there's maybe I'm probably a little bit too ignorant, and there's maybe a couple of things that need clarifying to give a more useful answer. So for this person, if they want to just come back and just maybe kind of, as I say, put us right and see if we can come up with a better answer next week or something, we'll give it our best. So not the greatest start, but let's keep going. There are some questions we can answer in this lot, which is useful. So next question. If the council uphold your complaints and offer you compensation, what happens if you are happy with the amount they offered you? Can you still take the matter to the ombudsman? Now, I'm not quite sure if this is a typo in terms of if you are happy or you aren't happy, but either way, there's probably a little bit of interesting stuff to say about this. So let's say, and I'll give you an example. So I made a complaint to Shepway many years ago for a lady who was fleeing domestic abuse from Bedford, went to Shepway. They first of all insisted she provided proof of pregnancy rather than accepting the application properly as they should have. And then their basically only kind of intervention was to get the local charity there to get a bus ticket for them back to Bedford. So went down the complaint process with them. They offered like something quite insulting, like £150 or something at second stage. First stage, as I say, never gets upheld. But second stage, they kind of said, yeah, do you know what, we'll pay £150, which is really stupid because that's basically them accepting that they were wrong, but it was not in line with the LGO's kind of guidance and remedies. So what it meant was when it went to the LGO, they not only offered more money, but they also it was then published. So there's then kind of like that public access to the fact that Shepway did something pretty stupid and pretty a bit of a never event really. So that'd be the answer if you're not happy with the amount they paid. If you are happy with the amount they paid, there would still be other remedies that they can, so it's not all about money. So you might actually want a proper apology and they don't give you a proper apology. You might simply want it to go into the public domain. So, you might be perfectly happy with the council's final stage complaint response, but you might think, well, do you know what? This isn't good enough. It's not going to hold the council to account. You could then take it to the LGO, and what the LGO would most likely say is, we can't add to what the council's already done. The steps they've taken to remedy it have been enough. But I think they would then publish that decision. Even though they haven't actually made any kind of meaningful change to the outcome, they would still publish it. Which again, politically, it can be more of an incentive for councils to improve than just the money itself. So, yeah, I don't know. Again, you guys got anything to add to that one? No? Cool. Okay. Third one. So this is a nice, easy one. So this kind of ties in with the video I did this week. So if you're not in priority need and the council accepts the relief duty, are you entitled to temporary accommodation? The answer is no, you're not, because the duty to provide interim and temporary accommodation, well, the interim duty only kicks in if there's reason to believe that you might be in priority need. So there has to be a possibility that you are. Whereas if you know for sure that you're not, so if you're fit and healthy, you're not pregnant, you haven't been homeless because of fire or flood or anything like that, whole list, then the council's interim duty would not kick in. They still do have a power, I think, to house you, but they are ridiculously unlikely to actually exercise that power. But you know, technically they could do if they wanted to, but they're effectively looking to protect their resources, which is legitimate to do. So the answer is no, basically. But I would, you know, as I always say in the training I do, most people who are homeless, who remain homeless for any length of time and who are needing to go to professional services to get help, there will often be things about them which means they might be in priority need. So there aren't many kind of fit and healthy people out there who are homeless for any length of time, because essentially the definition of priority need takes into account your ability to kind of secure accommodation for yourself. So if you're still homeless a few months later or something, that shows that you've not been able to do it. So there would be potentially something in there which means you might be in priority need. Anything you want to add to that one, guys?
No, I agree with you, unfortunately.
Yeah. Okay. Number 4, I think. Yeah. Do I need medical letter from my GP for moving on medical grounds or just my medical information? I'm really stuck if I need one or not, as the form for moving on medical grounds states we don't need a letter from the GP. Please help. Thank you. So there'll be various situations when you would want medical evidence. It might be that you're trying to show that you're in priority need, but in this case, you're essentially just trying to show that the property you're in is for some reason unsuitable for your medical condition. So it might be something simple like you've developed a mobility issue and you need a level access shower, or something like that, or you can't do stairs or something. I mean, I haven't got a lot to say about this one, but you guys might have more. But I guess my first answer would be, I rarely trust the council to make proper inquiries without a little bit of encouragement. So if you leave it to a council to make medical inquiries, they'll often ask for the absolute bare minimum, which won't then be enough to actually prove your case. So I would say that a letter from a GP is not going to hurt. The key thing with a letter from a GP is to make sure they actually make a comment on what they need to make a comment on. So if the issue is you can't do stairs and you've got stairs in your property, then the GP needs to say something about your ability to get up and down stairs. There's no point just getting like a patient summary or whatever, which you just got what medication you're on or something, because that doesn't prove the point. But equally, it sounds like this council, they've obviously got sort of set ways of doing things, but there's nothing stopping you going outside what they're trying to restrict. So I think that potentially that's just a case of the council trying to minimise what medical information they get back just by kind of sticking to a particular format. But I know. You want to add to that at all, guys?
I think the only thing to add is I read it as potentially it was a housing association, in which case normally they get an occupational therapist involved. So again, I don't think you would need a letter from your GP, but it's not going to hurt. So if you've got sort of the energy to like you say, get a good letter from the GP, it's only going to help. Particularly if there's sort of nuances around whatever condition or whatever it is as to why you need to move. But yeah, potentially they'll get occupational health involved. Just be aware of that, and they might come and do their own assessment as well. So that might be why they say they don't need it on the form. Sorry.
Yeah, cool. Okay, next one. I've been quite efficient this week. Well, you guys are anyway. If I can find the right thing, here we go. Okay, so this one here, I'm just going to mention it because we're not going to be able to do this one properly tonight. But basically, a question came in. Please, could you do a video on how to appeal to county court yourself if you can't find a legal aid lawyer to do it for you? Now, all I'm just doing is just flagging this because I did mention this one to Will earlier in the week, and I think we are going to try and do a video of how it can be done, because technically it can be done. I've never done it myself, but I guess, in the fact that it's quite difficult to get legal aid funded lawyers for housing issues, it's possible. So we'll try and sort of set out the steps. So basically, I'm really just kind of flagging this just to watch this space. We'll try and do it, I don't know, when we get around to it, when we get time. But yeah, it is possible to do it, and therefore we'll try and kind of do like a step-by-step video about how you can get that far. So that's that one there. We've got one about verification of rough sleepers, one of our favourite topics. So a rough sleeper has been verified by the borough's outreach team and who has submitted a homeless application has been closed by that borough due to no local connection. Is that correct? I thought the duty should remain with that borough and at their discretion, a referral made to the borough where the rough sleeper has local connection until another borough picks up the rough sleeper, should the duty remain with the initial borough. Yes. So this person, whoever asked this, is right. And it's probably just worth kind of talking through how local connection kicks in. I mean, it's not just about people rough sleeping. It could be anyone who's, where local connections are issue. Rough sleeping, there is a little bit, it's kind of a special category of local connection. So if you look in chapter 10 of the Code of Guidance, I think it's 10.6 maybe, or 10.9, I can't remember. But basically it says that when you're assessing whether a person rough sleeping has got a local connection, it's a different test from like a person who's become homeless from more settled accommodation. So effectively, if that person has been genuinely residing in the district, so that might be evidence because they've had contact with professional services, or they might have got a GP registration or something like that, then that would be enough to get local connection. But even if it's not, so you might have just someone who's rough sleeping, they've just literally just come to the district yesterday. They make a homeless application. They can make a homeless application anywhere they want. The council have to accept that application. They need to start their inquiry. So they need to work out if they are in fact homeless, which they almost certainly will be, if they are eligible for assistance, which is like having recourse to public funds. And if there's reason to believe that they might be in priority need, then that council need to provide interim accommodation. They then go a bit further. So they then do an assessment. So they then basically assess, what caused the person to become homeless, what type of accommodation do they need, and what support do they need to maintain it. And they need to do a personalised housing plan. Only when they've done those steps can they then make a referral to another local authority. And making a referral to another local authority is not just saying, hop it, we don't want you here, go back to another council. That first council needs to write to the second council and kind of go through a formal kind of process. So it's under section 198, you don't need to remember that, but section 198, where the other council would essentially receive that formal referral, and they then basically continue the application there. But basically this person's right. You can't avoid those initial duties to accept an application, provide interim accommodation if it applies, do an assessment, and do a personalised housing plan. That's kind of, they have to be done before the local connection kicks in. Shannon?
Yeah, so because they can't do that, right? I'd really struggle to believe that the local authority put this in writing and like a notification, because it wouldn't be legal, right? So I would sort of go back a step further as well and sort of just remake the homeless application, because I don't think one has actually been sort of officially made, but well, it's been attempted, but it's been gatekept, because like you say, the rest of it's illegal or unlawful. So therefore I would wonder if actually that homeless application was even made, particularly because you've got the red flag that is verification in there as well. So that's all. I would sort of just make sure you've actually done the sort of homelessness application bit, so to trigger the rest.
And that person would probably be eligible for about maybe a couple of £100 compensation, because there's this avoidable distress and anxiety or delay, or whatever you want to call it, within the remedy guidance, which would apply to someone who's not had an application accepted when they should have. So if that person, I mean, again, if you're in that sort of team, if you're in a rough sleeper team, you're probably paid by the local authority. You'll probably get in trouble if you complain to the local authority. And I would say do it anyway, but I know a lot of people wouldn't say that. But what you can do is you can basically just write a complaint letter for them, write or cover all the different bits that are relevant, talk to them about it, talk them through it. And if they're happy with it, they can sign it and send it themselves. And that has the same effect. So you can effectively support them through that process without having your name attached to it. So you're not going to have the same problem about, getting a manager, kind of telling you stop doing it, whatever. So, and I would say that because, because people rough sleeping have rights, and because they could be eligible for compensation, then I just think it would be unethical to not kind of explore that with someone. If you can't just surrender someone else's rights because it's inconvenient for you and because it might cause you trouble. These are rights which were kind of designed to be very good for people, and it's as I say, it's kind of, I don't think it's defensible to basically not complain because the council might wrap your knuckles or whatever. Cool. Next question. There's 11 that came in through the week, if you're wondering, guys. You're right, Martin. You're right, Andrew. Nice to have you here. 7. So a friend is living in supported living, but is very unhappy there due to antisocial behaviour from other residents. Can she ask the council to move her? Can you be put into other temporary accommodation without priority need? So I did a video on the channel this week about the duty to people without a priority need, which there are still duties to people, but it doesn't include putting a roof over your head. But just so we kind of explore this in a little bit more detail. So I mean, you can always ask a council to move you. There's nothing to lose by doing that other than the time and the frustration you get from dealing with a council. So some councils, for example, if you went into a decent council with a decent housing officer and say, look, I'm in supported accommodation, it's an absolute dive, there's all this stuff going on, I can't deal with it, then at nothing else, they could potentially refer you, or they could tell you about other supported accommodation that you'd be able to apply to. So not all supported accommodation is the same. Some of it's all right. Some of it's dreadful. And it opens up the possibility of making the argument that because it's making your mental health worse, then it might not be reasonable to continue to occupy that accommodation. I mean, that's we said it before. That's a high hurdle to cross in terms of making that argument, but it can be done. You would need very, very. I would say, in my experience, you need very clear evidence from a doctor or a psychiatrist saying that first of all you've got some significant mental health issues, and secondly that the current accommodation is the thing which is making it worse. So and having said all that, if you've got significant, if you've got poor mental health, then you might be in priority need. That's one of the things, it's one of the most kind of common things that leads people to be in priority need. So yeah, Shannon, you got anything to say on that one?
Yeah, I guess so. If you're in supported living, I'd assume, even if it's just on paper, there's some support needs. And depending on the type of accommodation, and it really does depend on the type of accommodation. And I've done it before with people where the support workers have still not quite got it right. But you could potentially ask the support accommodation to provide a sort of a letter saying, look, this person's support needs is too high for our project. It's not their fault. And so you're almost getting them like a no fault sort of eviction-y. I know it's often a license for supported accommodation. But it would also then give the local authority reason to believe you might be in priority need because you're saying your support needs are actually too high for the support accommodation. And arguably, if you're struggling because of the antisocial behaviour that's within support accommodation, it's not a stretch. And again, I sort of think any support worker that's working within support accommodation that's got a situation like this, why not? Like, what have you got to lose from And there's obviously nuances as well. Like you can say, like 14 days, we're going to evict this person, and you can say to the client, look, we're not actually going to kick you out and make you sort of sleep in, and you can sort of have those conversations. But yeah, I've sort of done that before with clients, and it's been quite effective. But it just depends on the sort of supported living provider and the situation as to whether that would work, I think.
Yeah, it's probably easier to run the argument if it's not like kind of registered supported accommodation, so it's not commissioned service, because effectively what we're saying, we're asking the council to accept that the accommodation is rubbish, and if they're commissioning it themselves, it's quite difficult for them to say that politically, even though it might be true. Whereas if you've got those kind of cowboy supported accommodation providers that kind of say that they're doing a great job and they're actually terrible, some councils don't care at all about kind of slagging them off, because actually those types of accommodation cost them a lot more money. So a lot of councils don't like those cowboy supported accommodation just because they have to pay more money out for it, basically.
Well, I think as well, it's more like actually you're just saying the person's support needs are too high rather than anything about the accommodation being poor. So a lot of support accommodations on paper behind the scenes have policies about they'll only accept sort of low risk individuals. Some are medium risk, some are high risk. Personality disorder, you're high risk, and there's all these weird sort of categories that they don't disclose to anyone when you're applying. But yeah, so I don't think it would even, you again potentially get away with it even with a registered one, because if they're down as medium risk and you say this person's too high risk for us now as a worker, and yeah. I'm not saying it'd be true, but yeah.
I mean, so I think some in this situation now would be a good time to go to a GP and just tell your GP how you're doing, so your GP could basically just make sure you've got up-to-date records and stuff like that. And then potentially that, as Shannon's talking about, so kind of, discussing that with your support staff and seeing if they can be helpful, basically. Right, next one. Number 8. woman currently living with a partner. The father of a child is in his mortgaged house, is required to leave as their relationship has broken down beyond repair. And he's become very controlling and has asked her to leave the home. She has no access to funds except a joint UC claim with him, but he gets the money. What would be the process in getting her housed or support with finances? So this was actually a question we saw in the Facebook group this week. And I kind of gave a bit of an answer to it, but I wanted to just kind of talk about it here because there's from a housing law point of view, it's fairly straightforward, but there's a lot of other things happening here which would actually make it quite difficult to support someone in this circumstance. There's quite a lot of things to consider. So basically, there's the housing law is generally really good. There's a really like odd kind of case, I think it's called Moncada or something from the late 90s, where effectively there was a relationship breakdown not involving, I mean, this was back when it was domestic violence rather than domestic abuse. So what didn't involve domestic violence. And the judge effectively said, you guys, even though you're not kind of, you're not kind of abusing each other, and the fact your relationship's breaking down, you're expected to live together, even though in that case, I think the lady had brought her new partner to live there as well. So the ex-partner was expected to live in the house with his ex-partner and her new partner. So that's kind of the first thing that's difficult here. I mean, if he owns the property and they're not married, and Will, you might correct me here if I'm wrong, there's nothing stopping him essentially just kind of kicking her out. And that might actually be quite, in a weird way, that might be quite good for her because that means she's then homeless. That means she can then kind of access kind of other support that might be available. So that's kind of the first thing to say. The second issue we've got here is obviously the fact that there's potentially domestic abuse going on here. So controlling and coercive behaviour is one of the various categories of domestic abuse, and probably the hardest to evidence. It gets quite intricate, but basically, I think I can't remember which the name of the act. It came in 2015, which was like when coercion and control became a criminal offence, and the police have got quite strict guidelines about what kind of constitutes this kind of offence. However, I would say that because housing law is under civil law and obviously not criminal law, then potentially you might have situations which don't quite meet the police's kind of criteria for coercion and control, but it might still be domestic abuse under kind of civil law under the Housing Act, that sort of thing. So pragmatically speaking, I think one of the things you'd want to do with this person is try and kind of just offer them support and just kind of get them to just take some time to make sense of what's going on for them and kind of work out, okay, is this person subject to abuse? Because it's very difficult to tell sometimes. You can have a relationship breakdown where it's very unpleasant for both parties, but that doesn't necessarily mean that there's domestic abuse occurring. But obviously, it's reasonably likely to kind of kick in at that point. The fact also that you've got a joint UC claim, that obviously needs sorting out with DWP. So the woman needs to update them that they're kind of that the relationship's broken down and kind of get that all set up so that it's coming straight to her, so she's actually got some finances. That would also potentially help if there's some coercion control going on with the finances in general. So yeah, I think I don't know. Have you guys got any other thoughts on that one?
I'm a bit worried that the reference to no access to funds there means no recourse to public funds. So I
thought that, but then accept a joint UC claim. So the fact, I hear what you're saying. Because I saw someone else in the group kind of made the same conclusion, but I would say she's got no funds other than the joint UC claim, which is effectively going to him. But that would suggest that she is eligible. That would be my reading of it.
Just in practical terms, she's got no access to money, but she's got her immigration status means that she could have. So that means she's eligible. But otherwise, it's Children Act for both housing and finances on the basis of destitution. So that she'd have to approach Children's Services. But if she is eligible, then she could make a homelessness application, like you were saying.
Yeah, and this would be another one where if you had a good counsel with a good housing officer, they are supposed to be there to provide competent advice and assistance. So you should be able to walk into any council and basically say, "This is my situation. What do you suggest?" And they should basically tell you what we're trying to tell you now in terms of these are your options. Unfortunately, again, councils don't volunteer this kind of information, which is essentially why we're doing this live stream or why we have jobs. And I as well with potentially you'd be looking to, you know, to access a specialist domestic abuse service, which they tend to be really good, except that they may not have any specific expertise when it comes to the homelessness law side of all this stuff. So, you know, effectively, and there's questions like, you know, does the child, you know, where does the child end up living? Because I'd imagine if she went to a council, the council would say, well, the child can live with the father, and that means that the mother doesn't have an automatic priority need. So there's other kind of things like that at play here as well. But I think, yeah, so as I say, that I just wanted to kind of raise the question here because I think there's a number of things going on which you'd want to have a look at to actually get a good outcome. But yeah, Shannon.
Just a couple of things on, I guess, the finance side of things. If I'm right, I'm pretty sure she wouldn't have to update their claim. She'd have to make a whole new claim. And then within that process, you essentially explain that you used to have a joint claim. It would be down to him to update the claim to take her off. And then in that way as well, you could get the month's advance sort of earlier. And if it's a case of sort of no bank account, there's sort of like local credit unions that are often quite flexible in signing people up, as well as some big name banks. I think Lloyds and Santander had like a homelessness sort of like you didn't have to have like a registered address with a tenancy, and that sort of like, particularly if you are going into interim accommodation. Starling's a digital one, so again it's slightly easier if you've got like controlling coercive stuff and can't access paperwork perhaps. Post office, like there's other options, and the DWP would be able to help you with that, so you can still go and set up a claim even if you don't have a bank account. They can help support you then to set up a bank account as well. Not many people sort of know that that's within the DWP scope, but it is. So yeah.
Yeah, cool. That's helpful. I mean, I think I've certainly seen cases where this is, you know, this is the information that's presented in the first instance, and then as you get to know the person more, and they're thinking through all this sort of stuff, and potentially there's like a specialist domestic abuse worker involved who's kind of, you know, talking about the more you know, kind of hidden types of domestic abuse. The person does start to realize actually there's a whole bunch of other behaviors which are going on, which would certainly mean that they are subject to abuse. So I've certainly worked, as I say, seen cases where things can escalate, and suddenly, you know, actually when you look into it in a bit more detail, there's a lot more evidence that the person is subject to domestic abuse. And just to kind of reiterate, as we often do with this stuff, when you go to make a homeless application, you don't need a letter from the police. It helps if you got one, but often you won't have one. The council's default position should be to believe you. That's the way the LGO has given very clear guidance on that. So as I say, it's very difficult often to kind of really evidence to an unsympathetic housing officer that you're subject to coercion and control, but all the more reason to have a decent professional alongside you just to kind of help you out of that process. Cool. So number 9, how are we doing for time? We're doing all right. Family of 5, 2 parents, 3 kids. The ages there. We're living in a hotel for 26 weeks. Then moved to a 1-bedroom temporary accommodation with a kitchen. Is there possible compensation for overcrowded in temporary accommodation? They've been there for 3 months. Sandwell Council, they were accepted for main housing duty 3 months after they moved into the hostel, so into the hotel. So the fact that the main duty's now been accepted means you are now able to ask for a review of the suitability of that TA. So you need to do that. But in answer to the question, could you get compensation? If you go back to the beginning of the video tonight, I went through a case, or 2 cases in effect, which involved this kind of thing and very large compensation payouts. So my answer is almost certainly yes, you'd be eligible for a fairly significant sum of compensation for this, based on that information. But in terms of getting the situation sorted out now, which is kind of the priority, you need to ask for a review of the suitability of the current accommodation. And you know, if it's overcrowded or if it's a hotel accommodation, I'm just trying to work out that's so. I'm trying to work out the timeline here. Moved into 1-bedroom accommodation with a kitchen. That sounds like it's overcrowded TA rather than it being a hotel accommodation. But it seems like there'll be an element of compensation for living in a hotel for 26 weeks. In fact, there's definitely one. So you can't be put in a hotel with when you've got children for more than 6 weeks. So you basically, there's 20 weeks over the limit there. So the LGO recommends between £100 and £200 per week you're in. You ask for £200 because you're acting in your own interest. You're allowed to do that. So that would be a payment of some, maybe as much as £4,000, if my maths is right. 20, yeah, 200 times 20, yeah. So £4,000. That's a starting point. Plus potentially you then got this element for for the kind of the overcrowded TA now. So yes, is the short answer. Go do it basically. And before you do it, do a subject access request just so you can prove all the dates. Shannon?
Yeah, just a really quick comment because we've talked about compensation a few times. Compensation isn't won't affect benefits. It won't affect sort of like the housing benefit for temporary accommodation or anything like that. Like it's exempt from that, if that makes sense. So don't like hold off on taking it to the LGO or hold off getting compensation because you think, it's going to count as income. It doesn't. So yeah, I just wanted to make that clear to people, I guess.
Yeah, cool. I feel like we've missed the question here because I'm on 11 on my cheat sheet and we're on 12. Oh, no, yeah, we'll see what happens. I'll just check I haven't missed one in a minute. So, and I think this one's going to be on you, Will. So section 21 struck out. Let's get rid of this. Here we go. Section 21 struck out, but court papers say the landlord can apply to restore the claim for possession within 28 days. If the landlord does restore the claim, do you need to submit a new homes application or is the current one still valid? What if the landlord applies straight away for a new section 21 instead? Do you need to do a fresh homes application in that case and start it all over? Will, I mean, my short answer is if the council didn't issue a not homeless decision whilst that got struck out and basically didn't do anything at all, and then the landlord proceeds and actually issues another one, then you would need to make a fresh application because you're still homeless and it's almost still running. However, if the council was on the ball, they might issue a not homeless decision when it's struck out. But yeah, Will, do you want to fill in, talk about that?
Yes. It's a bit of a confusing scenario, this, because normally with a court case, it's either live or it's struck out. And I can see that you could strike the case out and then say, well, if you can show that we were wrong to strike it out within 28 days, we'll restore it. And that may happen in the type of case because Section 21 possession cases, they are dealt with under what's called the accelerated procedure. And what that means is the landlord sends all the papers in and then the court sends them out to the tenant with a defense form and says, have you got anything, basically says, have you got anything to say why you shouldn't be evicted? Has the landlord made any mistakes? And if the tenant doesn't do anything, then the court will make a possession order without a hearing. But equally, if the judge sees that the landlord's got something wrong, they may not even bother asking the tenant to point it out. So they could say on the face of it, for instance, if the landlord's answered the question, have you protected the deposit? And the landlord says no. The judge will say, well, that's the end of your claim because if you don't protect the tenant's deposit, then Section 21 notice is not valid. But for instance, it may be that the judge was thinking, well, if the landlord wants to say, oh, sorry about that, I ticked no when I should have ticked yes, here's the certificate, then they could restore it. So that's the background to that strange situation of where a case can be struck out but not struck out fully. And then the other point is your current homelessness application will, I think, still be valid if the council made a decision to say you're not homeless because the claim's been struck out and therefore you're able to live there, and then the claim was restored and a possession order was made, you could say to them, well, that was you shouldn't have withdrawn that. But you could just make a new application. You don't have to, because you could ask them to reconsider their decision in the light of new information. But if you did say, well, remember me, you said that I wasn't homeless, well, I am. And then the other point here is getting a bit technical, is remember it's the possession order that's been struck out, not the Section 21 notice, although it's presumably it's the claim for possession that's been struck out. The court doesn't strike out the notice. So if the claim was restored, then the question again would be, was there a valid notice of seeking possession, which is the one about they should treat you as threatened with homelessness. So without getting over technical, what I'd say is in that unusual situation, rather than write to the council and say, will you reconsider this, and wait for ages for them to tell you no and then challenge that. You'd be better off making a fresh application, because then they've got a duty to make inquiries again, and they've got a duty to provide you with temporary accommodation again if you need it. So I would say yes, it's often best to make a fresh application. It's not that big a deal. You just say, please, can you treat this email as setting out a request for you to process a fresh application? You don't need to sort of give them a whole load of papers, which they might ask for. So I hope that answers the question.
I think I followed it. Yeah, they didn't make the whole eviction process particularly user friendly in terms of terms, but I think I think that makes sense. Yeah, cool. Thanks, Will. Last question of the ones that came through the week. Then we get into the live chat. So my question is: does the applicant when they let me just get this right. So when they request a housing review of accepted the okay, right. So they've accepted the unsuitable accommodation, but they've as we would suggest that you should do if you get offered unsuitable accommodation, still accept it and then request a review of the suitability of it. So they're in that unsuitable accommodation whilst they wait for the review to be undertaken. Is there any hope they can be favoured? So is there any hope that they can get a positive decision? Can they get it overturned? And the answer is yes. But when you're challenging suitability of temporary accommodation or suitability of any accommodation offer, there are things which kind of are much more likely to hold weight. So things like, affordability is actually probably one of the easiest ones, I guess. But things like, say, kids' schools, support network, jobs, that sort of thing. Kind of friends and family, that sort of thing are all relevant. So I think it's probably time to do a good video about this again, because it's coming up a lot, obviously. We did do one before when the YR case had just come out. So there's a case called YR v Lambeth. Interestingly, I read today actually in I don't know the name of the case, but basically it was a Supreme Court case, and the judge said that council should have a publicly available policy about the location of accommodation, of any accommodation provided. So in the YR case, Lambeth did have such a policy, and Lambeth had basically breached their own policy on it. But a question came in with Hounslow, and I was looking on Hounslow's website today, and I couldn't see anything about kind of a location of accommodation policy. So you can challenge a council and say, why haven't you got a policy? In fact, that's on my list of things to ask Bedford Borough Council in the next one, because I don't think they've got one either. And they're also housing people out of area a lot. But yeah, so those are the sorts of things which are more likely to be successful. Often it's kind of like done on a technicality. So if the council didn't properly consider the needs of every household member and record the needs and how they assess them and so on, then effectively everything the council then do in terms of offering you something, it's just there's no way that they can prove they even considered the right things. But yes, the short answer is decisions regularly they frequently get overturned. In one sense, councils often make just bad decisions because they know some people don't bother challenging it because they think they can get away with it. So a lot of decisions that are challenged do get overturned, but you do want to focus on things which are relevant. So again, I think we just need to do a good video about that at some point soon. But yeah, Will or Shannon, do you want to add to that at all?
No, I haven't got anything else to add to that one.
Cool. I'm going to start loading up. There's a 3-part question on the live stream. So let me just get all this right. So I think that is, let's check I've got, I think that's all of them. So someone has been diagnosed with autism, prescribed the maximum dosage of antidepressants, and has now been referred to the secondary mental health team by his GP due to feeling suicidal. He's soon to be evicted from his family home as the domestics are at breaking point. I think that means kind of the kind of family relationship are at breaking point. However, he has high sensory issues and anxiety around people. Would the council deem him as a priority need? And if so, would he end up in a hostel or temporary accommodation? So great question. There is no diagnosis or health issue or whatever which would automatically mean you're in priority needs. However, someone who has got autism, which almost certainly will have a big impact on their life and kind of lead to things like anxiety and so on, they are in priority need basically. But you need to kind of go through a bit of a process of explaining what happens to that person if they were to become homeless. So it's not enough to say, I've got X, Y, and Z diagnosis. You have to say, or ideally you get a doctor to say, Mike has got, depression, anxiety, and suicidal ideation. if he was homeless, there would be a high risk of it getting worse. That would then put you into the ballpark of being in priority needs. So I think the answer is ideally get a decent advocate, because it's quite a complicated argument to make. And yeah, you know, bottom line is obviously autism is a significant issue, as is anxiety and depression. That immediately differentiates you from an ordinary, healthy, and robust person. And I use those words. It sounds horrible words, but I use those words because that's the kind of legal test of it. So you compare yourself to someone who doesn't have any conditions at all, and you work out, you know, would you fare considerably worse than they would if you were homeless? And if the answer is yes, then you're in priority need. So that's the first thing. Second thing, would you end up in hostel or temporary accommodation? So these are all kind of like technical jargon, which mean different things in different areas of the country. Certainly in London, it seems you just get, like, by default, you just get dumped into a block of flats, which are kind of, lots of people with lots of different issues, lots of antisocial behaviour, lots of noise, that sort of thing. So you can absolutely request, essentially what you want to do is you want to state to the council, I've got autism, I've got anxiety, these are disabilities, and therefore I want the council to carefully consider these disabilities and provide me with accommodation which is peaceful and not kind of an antisocial behaviour hotspot and is self-contained. That's obviously not going to guarantee the council doing following the law, because councils break the law all the time. But it would be a very good argument from a legal point of view that they should actually carefully consider that and try their best to work. I mean, in fact, if we go to that, the first or second LGO complaint I put up there involved a lady with autism, and the council was found to be at fault because they hadn't made any adaptations or reasonable adjustments to their service because of that, even though she spelt out what it was they needed to do. So in that case, she basically asked them to communicate kind of much more clearly, kind of break things down and make sure she understood it, and they made no effort whatsoever to do that, which is why they kind of had to pay so much compensation. So yeah, absolutely. I mean, what I'd also suggest is see if you can find maybe a specialist charity or something locally that kind of supports people with autism, because you might get lucky with someone who, they might not know housing law, but they might have that sort of kind of fight in them to go and find someone who does know about housing law and actually get you that right support. So yeah, the law is good. The law around this stuff is really good. The problem is just the councils don't follow it. That's the issue here. So you need to find a way to make the council follow the law. Will or Shannon, do you want to add anything to that one?
Could I just add that I think that the answer to the question about will they be found to be in priority need and will they be put in hostel rather than non-hostel accommodation is they should be. I think they should be found to be in priority need, and due to their condition, they should not be put in hostel accommodation. But without wishing to sound unnecessarily grim, I would say that the rule you have to follow here is that if something is capable of going wrong, there's a real risk that the council will ensure that it does go wrong and that they will not be found to be intentionally homeless. And there'll be some decision from now, advice from Now Medical saying standard medication, nothing, no psychosis. And then there'll be something saying that there's nothing to believe that hostel would be unsuitable if they did accept the duty. And I would say that anyone doubting this or wants to see how bad it is in reality should watch that video that you put up there yesterday, Mike, the one called Not Exceptional Case, The Grim Realities for Homeless Applicants. Because if you watch that video, you'll see that just about everything, every service that the law helpfully provides should be provided to that applicant was denied her by incompetence and malevolence on the part of staff. So my advice is be ready to challenge. Even the strongest case may get messed around, and you should be ready to make a complaint and get the subject access request in early.
Yeah, and I think as we always say, involve local politicians to find out who your local councillors are, find out who your new MP. You may well have a new MP now who wants to kind of stamp their feet a little bit and kind of make it look like they're doing some good work. And yeah, I mean, and just keep asking around to see if you can find a local service which is decent, and as I say, and which is willing to challenge the local authority. It'll make a massive difference. So yeah, I wish you all the best for that one. So yeah, difficult one. Yeah, and just to echo what Will just said, councils would tend to, vulnerable people are more easy to gatekeep and fob off. So they tend to be actually there. And the more vulnerable you are, the more likely it is the council will try and play games with you and stuff and make it hard. So whereas if you're a bit of a Karen and you kind of stamp your feet and kind of involve politicians early, then you're more likely to get better outcome, which is why we suggest doing it basically. So next question. A friend who fled abuse and is in temporary accommodation is in Band D on register, has no local connection even after review. Can new medical information of PTSD from GP change this even with no local connection? So this is an interesting one, because if, there's maybe some issues around terminology here. So temporary accommodation, when I use that word, I'm talking about accommodation which the council has provided under the homelessness duties it has, which is fancy word for that is Part 7 of the Housing Act, or fancy term is Part 7 of the Housing Act. If you're fleeing domestic abuse, local connection doesn't kick in the same way it normally would do. So in one sense, if you're fleeing, if you're homeless because of domestic abuse, you are immediately in priority needs, which means any council in the country you go to would have to accept the homeless application, and they'll reasonably that you're in priority needs, so they'd have to put you in interim accommodation, and they couldn't refer you back to your home area if there was any risk to you of domestic abuse there, and that's quite a low threshold basically. So the idea that local connection is being used here is it just seems like something is very badly wrong. There's just no, I don't know, local connection. What I think council officers do is, because they don't get any training often, they're not very bright, let's face it, they kind of just apply this sort of like stupid mentality where they don't go and find out what the right answer is. So what I suspect is happening here is that you're speaking to someone from the housing register team who doesn't understand there are two different definitions of local connection, and they're confusing the two things and just making a mess. And so what I'd probably suggest that person does is they just essentially try and unpick it, go back, have they had letters from the homelessness team about, Section 184? Does it mention Section 184? Does it mention Section 193, which is the kind of the main housing duty, which is what I'd expect someone in the situation to be owed? And if you're owed Section 193, local connection just doesn't kick in. You might not satisfy the housing register definition of local connection, but you don't have to if you've gone down the homeless route and you're owed Section 193. So it's just a very odd situation. And the medical information about PTSD, I just don't. I mean, it wouldn't be relevant to local connection. I can't see how it would be, other than the council is messing something up badly here. So potentially, I don't know, how would you get around this? I'd certainly read the housing allocation scheme, which is what the banding comes from. And I'd imagine, I don't know. I mean, for this person, I'm just going to say, if you want to put a comment on one of the videos, and we'll have maybe a very brief conversation about which council it is, and I'll have a look at the housing allocation scheme there, because something stinks about this. Basically, I just don't see how this could be possible. I think the council is just giving just absolute garbled information, and they don't know what they're doing. Basically, I think that's what's happening. I can't see any situation where you would need medical evidence of anything to do with local connection. You might need, or you might want to get supporting evidence that you are at risk in a particular area, because that would be relevant to local connection, but not PT. I just don't see how it would kick in. So yeah, I'm not sure. Unless Shannon and Will, you've got any bright ideas, I don't know, we can answer any more here. But as I say, if you put a comment on any video on the channel, I'll try and be a bit more helpful if I can just kind of know the particulars of which council it is and stuff, and have a look at their policy. Next question. Is agoraphobia classed as a priority need? So as I've kind of said in the previous answer, there is no diagnosis which means that you are or you're not in priority need. So although council staff are trained that they're often kind of given training from organisations, medical advisors or whatever, where they're kind of given like a checklist, like cancer, that's priority need, depression, that's not in priority need. The fact of the matter is that pretty much any health condition could in theory lead you to be in priority need, unless it was a really trivial minor one. So the answer is it could do. I would say with agoraphobia, is the key thing is okay, how does it, assuming we're talking about anxiety stuff here, well, yeah, it says in the question, isn't it? So you really, what you'd want to know is what would happen to a person with agoraphobia if they were to become homeless. How would they deal with being homeless if that was the case? and potentially there would be the possibility that that person's mental health will deteriorate very rapidly. It might lead to other kind of negative coping strategies like self-harm or something like that. So that's kind of how you would make the argument. But in itself, you couldn't just go to a counsellor and say, I've got agoraphobia, I'm therefore in priority need. That's just not the way the law works. You have to explain why it makes you more vulnerable than someone without agoraphobia would be if you were homeless, and how you'd be at risk of more harm than someone without agoraphobia would be at. Again, Shannon will just kind of kick in if you want to say anything. I'm just going to kind of go through these few more questions here. So question 16, and this is a two-parter at least, so I'll make sure I've got it all. Somebody suffering with post-traumatic trauma disorder, I guess we're talking about PTSD there. I mean, there might be a separate diagnosis these days. The ICD-11, which is the kind of the list, the kind of the encyclopedia of diagnosis, has just basically broadened a lot of mental health issues, actually. So who knows? Made new application under his name because his mum was previously found intentionally homeless due to rent arrears. Will it impact outcome of new application worried his mum was joint tenant with his husband who has passed away? Okay, so I'm just trying to, so we're talking here about a couple of things which I can tell you off the bat. I'm just trying to work out if I've read that properly. So first thing is that there's no such thing as an intentionally homeless family or household. It's just about an individual. So if the mum has been found intentionally homeless, the son, I'm not quite sure. I'm not quite sure if I follow this, but the other family member can make an application in their name, provided they're over the age of 16 and they have mental capacity, which they probably will be. So they can make an application. The council will be allowed to assume that whatever it was that the mum did that led them to being intentionally homeless, they can assume that other family members acquiesced in that behaviour. So let's say, for example, let's say it was the dad, he chose not to pay the rent because the landlord wasn't carrying out the repairs, was then found intentionally homeless, and then the mum then made an application in her name. The council would be at liberty to say that they both knew about it and they both kind of acquiesced in that behaviour. So the mum would also be intentionally homeless. But if the other family member didn't know about what it was that was leading the person to be homeless, so it might be that they didn't know that rent arrears was accruing, or it might be they didn't know that, I don't know what else the situation might be in. But so they would have to kind of show that they didn't acquiesce in it. Yeah, as I say, I'm not quite. I just kind of trying to work out if I've actually read that question out properly. The other thing to say is that if you're found intentionally homeless, always challenge it. You've got 21 days, always challenge it, because there's a number of kind of defences that might kick in. If you look in chapter 9 of the Code of Guidance, there's some key things which, again, housing officers, they'll see something like rent arrears and they'll be like, oh, you're intentionally homeless, when you're not at all. There's other things going on. So, yeah, Will or Shannon, do you want to correct me if I've just misread that question? Was that, have I missed something there?
I think it's quite a confusing question, because initially it says that the mother became intentionally homeless due to rent arrears, but then said she was a joint tenant with a husband who passed away. But I'm assuming that must have been before she lost the property due to rent arrears. But I don't think that would be a cause for concern particularly. But the good news is that if the mother was in priority need, which presumably she must have been for them to have found her intentionally homeless, because they wouldn't have bothered considering intentionality if they hadn't found her in priority need, and that wasn't because she had a child living with her who's no longer living with her or no longer a child, then any family member, like you say, Mike, can make an application, and they don't need to be in priority need themselves, because they can rely on the mother's priority need, because it's someone in their household who's in priority need. So that's good. And as long as if it's a family member who wasn't involved in the payment of the rent for the previous place, then it sounds like they have a good case.
Yeah, cool. Okay. There's a couple of questions in the live chat which are in the first person. So as I say, I'm not going to discuss them in detail. If they want to rephrase them, then I will put them into the document here. But I'm just trying to, I mean, they're just basically questions about priority needs. And essentially the first question sounds to me like that person is definitely in priority need. Again, there is no definite thing, but that is someone who clearly there's a lot of health issues going on. The person said there's mistakes in the decision and so on. So, yeah, again, it's just a case of just kind of getting a good advocate. And again, just housing officers, like they know what they're doing. They're just trying it on and seeing if they can basically avoid the duty. Now they've mentioned here the Mohammed case. So when you get given a non-priority decision, or in fact any negative decision that affects whether or not you kind of get interim or temporary accommodation, you can challenge it, and effectively, as long as you provide new information which is significant that wasn't considered in the original decision, and crucially you ask to be housed, which this person has done, then that duty would kick in. I think this person ideally wants to get a solicitor. I think this would be really easy for a solicitor just to win it. Just write a letter and they'll immediately fold. If you can't get a solicitor though, because obviously it's just not that easy, then involve politicians, complain, all of that sort of stuff, and just this is going to depend on just getting some really clear information from medics. So obviously it depends on what information's already been included in the original decision, but yeah. So and I just see now medical's involved. In my opinion, now medical are disgusting. In my opinion, they just harm a lot of people. In my opinion, and I don't know what they think the end game is, because all they're actually doing is making it easier for councils to get rid of people, and they don't vanish. They're still around. Those homeless people they still exist. It's not solved the issue. It's just meant that the council can save a quick buck in their housing department. So probably very easy to challenge if you can get a decent advocate. Just the question on that back, so someone just asked, where can you get a solicitor? So if you go on Will Flack's channel, so I don't know what your website is, Will. I used to always search for Will Flack Law and it comes up, so that might be what it's called. Yeah. So if you Google Will Flack Law, on that page, in fact, let's go there together so you can see it for yourself. Here we go. Just there's a lovely picture of you there, Will. But more importantly, there is somewhere on this blog. Have I got the right one actually? Because this isn't. No, this isn't.
That's
the blog.
That's
Hold
about.
on.
There's a bit with resources.
Here we go.
Yeah, and then resources.
So if you go, there we go. So if you go down here, you've got solicitors that basically, that kind of get legal aid. So you've got a number of numbers there. And just do bear in mind that because we live in the world of Zoom and kind of Teams or whatever, you don't necessarily need to live in those areas to get. So although it says South London, you don't need to go to their office necessarily. You probably don't to get the help. So there's a lot of contact details there. You will find, depressingly, that most of the ones you ring up will say they're at capacity. So you just have to be persistent with it. But yeah, I think for those people who just kind of ask those questions at the end there, if you want to just put a specific question on the channel, I might be able just to kind of give some more information about your council's kind of allocation scheme and so on. I might be able to give you some more information that might be helpful. So yeah, I think that's it.
So we've got like a really cool where you're sharing the YouTube channel, and obviously then it keeps resharing it. I feel like there's a certain name for it, but yeah, just so.
Yeah, like this. Sorry, you noticed that. Yeah, you could have gone for infinity, couldn't it?
Yeah.
Yeah, cool. So, right, that's it. Yeah, so next week, guys, Will and Shannon, you around? I don't know what date it is. What it'd be, the 18th. So, yeah.
So yes, unmuted. I am around.
Yeah, cool. And if you're watching this and you got this far and you found any of it helpful, do give it a like and a bit of a share. And if you haven't subscribed to the channel, do so because you get notifications. We've got some good videos in the pipeline at some point. We've got another video about vulnerability coming up. I think in a couple of weeks' time, we're going to record that live. We're going to go through some more cases. So we talked about some vulnerability cases tonight. We're going to talk about some other cases which are going into a bit more detail. So again, oh man, it's so sad that we have to say this stuff, but yeah, councils, the officers know what they're doing. They'll say that, we can't do anything. We've not got enough houses, but they don't have enough houses because they don't challenge it themselves. And it just leads very vulnerable people to being in a very bad situation. So yeah, I guess all we can say is just keep persisting. There's a lot of stuff on this YouTube channel which might help you out if you're in those situations. So for example, the questions about vulnerability, if you search for vulnerability or priority need on the channel, you get quite a few videos which are going into quite a lot of detail. So hopefully there'll be some stuff in there that'll help you out. And if you're a professional working in the sector, you need to start challenging your local councils because they're getting away with this stuff in broad daylight because no one's challenging them. So get to it, basically. Cool. All right, guys.